Welcome to another episode of Regulatory Oversight, a podcast that focuses on providing expert perspective on trends that drive regulatory enforcement activity. I'm Stephen Peepgrass, one of the hosts of the podcast and the leader of the firm's Regulatory Investigations, Strategy, and Enforcement Practice Group. This podcast features insights from members of our practice group, including its nationally ranked state attorneys general practice, as well as guest commentary from business leaders, regulatory experts, and current and former government officials. We cover a wide range of topics affecting businesses operating in highly regulated areas. Before we get started today, I want to remind all of our listeners to visit and subscribe to our blog at regulatoryoversight.com so they can stay up to date on developments and changes in the regulatory landscape. Today, my colleagues Gene Fishel and Joel Lutz speak with Aurelia Lewis and Beth Saunders of Lewis Media. By way of introduction, Gene Fishel is a member of our RISE practice group. He's the former chief of the Computer Crimes Section in the Office of the Attorney General of Virginia. Joel Lutz is a member of our Privacy and Cyber practice group and brings extensive experience in designing and implementing global privacy programs, including 19 years of combined in-house and law firm experience. Our guests, Aurelia Lewis, who is the founder and president of Lewis Media Partners and a good friend of mine, and Beth Saunders, who is its vice president, are both alumni of the well-known Martin Agency. Aurelia and Beth together bring over 60 years of world-class media channel planning and buying experience to the table. Over the past 26 years, they have transformed Lewis Media Partners into a highly respected media agency in its own right, serving clients in Virginia, the Southeast, and across the United States. Gene, Joel, Aurelia, and Beth focus on privacy laws and regulations of importance to small to mid-sized businesses. They discuss the challenges these businesses face seeking to comply with these laws, and they provide insights into what might attract regulatory attention to these businesses. I know we're all looking forward to this discussion.
Well, thank you, Stephen. And it's a pleasure to be joined by my colleague, Joel Lutz from here at Troutman. We're very much looking forward to this very interesting conversation with Aurelia Lewis and Beth Saunders of Lewis Media Partners. And I think we're going to cover some pertinent, relevant topics concerning privacy, and particularly as it relates to the laws that are proliferating at a rapid pace and how they apply to mid and small businesses that have to deal with them. So I want to kick it over to Aurelia first. Aurelia, if you could maybe just give a bit of an overview of the services that Lewis Media Partners provide and any pressing issues you all are seeing on your side.
Yeah, thank you, Gene. We are an advertising agency that specializes just in paid media. So we don't do creative here. However, with the consumer privacy laws, that's very top of mind. We're spending a lot of time with Google and Meta and a number of the digital platforms. So consumer privacy is definitely a top of mind topic here. We handle a variety of clients. We have about 40 clients, and they range in size. And one of the questions that we're trying to answer and to help our clients answer is, why should you care or pay attention to the consumer privacy laws right now? So that's a big topic, and we're trying to get everyone to sort of stand up and notice that this is an issue and it's going to be a growing issue.
Well, understandably, and right off the bat, as I mentioned, privacy laws, cybersecurity laws, they're proliferating across states at a rapid pace. And what I'll say is these laws do not discriminate based on the size of a company. So you could be a very large company, you could be a very small company, and you're likely going to have to comply with some sort of privacy statute or regulation. As of right now, just the other day, there are now 16 states that have passed a Consumer Data Privacy Protection Act. And these have been passed beginning in 2020 with California. The most recent one was Nebraska, I believe, who passed what are called CDPAs. And among the states, these consumer privacy acts, they can vary based on their provisions, but a lot of them share common elements. And those common elements can really be divided into two categories. One is consumer control, over their personal data. And the second is the regulation of data handling, how companies are handling this data. And so when it comes to consumer control, these CDPAs that are coming into effect, they require that companies provide notice to consumers as to how they're using their data, how they're processing the data. They provide consumers the right to access their data, what data is being collected, or confirm that it's being collected. They provide them the right to delete the data, the right to obtain a copy of the data, the right to correct the data. And also importantly, the laws require the right to opt out of the sale of data or from certain targeted advertising. So these are generally common themes across these various CDPAs that are being passed. On the data handling side, the laws require that companies limit the collection of certain data to what is adequate and relevant to the purpose it's being used for. Companies have to process it consistent with the notice that they're providing consumers as to what they're doing with their data and how they're collecting it. They have to implement, quote, reasonable physical, technical, and administrative data security practices surrounding the data. And finally, when we're talking about types of data involved, many of these statutes, most of these statutes will distinguish between personal identifying information, certain types of that, and also sensitive data. And sensitive data often includes children's data, data concerning religious beliefs, sexual orientation, mental health, immigration status, and even geolocation data. And with that sensitive information, most of these statutes require that companies obtain consent prior to processing the data. And so those are important common themes that companies need to be aware of concerning these CDPAs. There are certain volume requirements that trigger these laws, meaning in many cases, for example, in these state laws, companies have to be processing 100,000 consumers' data for the law to trigger, or they're obtaining at least 50% of their gross revenue from the sale of that data for these laws to trigger. So it's just very important. And of course, I'm giving a broad overview here. It's very important companies be aware of this, pay attention to the volume and the types of data they're collecting, and of course, consult with appropriate legal counsel to make sure that they're complying with other laws. Now, the other thing I want to mention is what kinds of data are we talking about? What are the data points that companies should be aware of? Well, as far as the CDPAs go that have been recently passed, it's fairly broad. Let's use California example. California was the first to pass back in 2020. They've been out in front of privacy issues. Under California, these laws are going to trigger with any information that, quote, identifies, relates to, describes, is reasonably capable of being associated with, or reasonably could be linked directly or indirectly with a particular consumer. So it's a very, very broad bucket of information that can fall within these. And like I said, this can even include internet activity, beyond just your typical personal identifying information, which of course could be name, address, social security number, financial account numbers, that sort of thing, driver's license numbers. But it can also include that internet browsing history, search history, geolocation data, as I mentioned. And so again, very sweeping acts that have been passed in the last 4 years. So far, 16 states. You have another at least 10 states now considering this legislation. And that is on top of the other privacy laws that have already existed. Database breach notification laws that require notification to consumers and a lot of times state attorneys general offices when you've been breached. There are data specific laws, of course, like HIPAA, federal regulations applying to medical information that is collected. There's Gramm-Leach-Bliley and financial information regulations. The Securities and Exchange Commission just this past year promulgated new regulations requiring notification for publicly held companies when they've suffered a material cybersecurity incident. So lots of regulations and laws across the landscape for companies to consider. And if they're not considering them or following them, it could result in litigation. And we've seen the litigation threat facing companies can be from class actions, major class actions against not only large companies, but mid to small companies, in addition to regulatory actions taken by government entities that companies really need to be aware of. That's sort of the landscape we're dealing with here. Aurelia, do you have any?
Yeah, so question, because we have a lot of nonprofits that we work with, and we are collecting data on that. Are the nonprofits excluded from this? We get that question asked a lot. And I think it's the other category might be education, higher education. So those are some of the questions that we're getting as well. Are there companies that are excluded from these laws?
I'm going to turn that over to Joel. Why don't you launch into this?
Sure. Thanks, Gene. So as Gene said, each of these states that have passed these comprehensive data privacy laws have different thresholds and requirements and exemptions. And most have some kind of exemption for nonprofits, but they vary by state. So you really have to look state by state. Some have blanket exemptions for nonprofits. Connecticut, Indiana, Iowa fall into this, where they just say this doesn't apply to nonprofits or nonprofit corporations as defined under their state laws. So you have to look at the state law and make sure that your nonprofit qualifies for that exemption. Other states limit which nonprofits are exempt based on the activities of the nonprofits. And these can get very specific state by state. So privacy laws in Delaware, for example, only exempt the nonprofits that are dedicated exclusively to preventing and addressing insurance crime, and nonprofits that provide services to victims of certain crimes of violence. So you can see that's a very specific type of nonprofit in Delaware that's exempt. And I raise that to say you really have to go state by state and know which state your nonprofit is potentially under the jurisdiction of, and then look at the exemption there. And there is at least one state, Colorado, that does not have an exemption for nonprofits. So I think the moral of that story is generally a lot of them exempt nonprofits, but you really have to look state by state.
Gotcha.
And just Aurelia, to pick up on the broader question of who do these laws apply to and what do you do when you have a small or mid-sized company? And really, I mean, Gene mentioned the thresholds, but each of these states has some sort of small business exemption, but they all craft them a little different. Most set a threshold of the volume of data that you collect about people and say, if you're under this volume, then you're exempt, effectively considered a small business. And usually that's 100,000 consumers, which may seem like a lot depending on how big your company is, but it's always important to remember that 100,000 counts visitors to your website if you collect data about them, like through cookies. So the data that Gene was mentioning that we don't usually or haven't historically in the US thought of as personally identifying information, like IP address and device ID, things that online trackers pick up, is now considered personal information under these statutes. So if you simply have a website and have some data analytics cookies running on it that collects that type of information, each of those visitors can count towards the 100,000 consumers that would reach the volume. Some other states lay on a revenue threshold for the small business exemption, and usually it varies by state that do that, but usually it's around $25 million in gross revenue. And then a few states kind of take the approach, like we mentioned with the nonprofit exemption, and they just say small businesses as defined under our state law are exempt. So again, I think this just highlights the first question when a company hears about the privacy regulations, the new privacy laws that the states are passing is, does this apply to me? And you really have to look at the jurisdiction, the type of business you are, the type of data you're collecting to figure out, does this apply to me or not?
I will say, Joel, yesterday we had a good meeting with a nonprofit, and I asked them the status of what they were doing on their end. And it was a very good conversation. And I was really happy to hear that they were being proactive and looking at the situation. So I applaud y'all. That's not really our field, but it was great that they were leaning into it. So that was good news.
It is good news. And there are other reasons for nonprofits to consider taking actions, taking some compliance steps, even if they are technically exempt from the statute. And one is really just like you're doing with those nonprofits and building trust in you as a service provider. They want to build trust with their clients. And so disclosing what data you collect about people is now the norm. It can also protect you from some of the litigation that Jean mentioned. So even if you're exempt as a nonprofit, there may be other business reasons to consider taking some of these steps around transparency and telling people what data you have about them, because that's frankly what consumers are beginning to expect in the United States now.
Definitely.
So Joel, I think you just hit on a great point about compliance. Most of our clients, all of our clients really want to be compliant, but there's so many nuances around that one of the most common questions we get is, how do I know that I'm in compliance?
Yeah, and that's a tough one. Obviously, that's why we're here. But I think it starts with some amount of data management or data governance. And those can be big, fancy words, but it really comes down to, for small companies that have grown big enough for this to be a concern, they need to have some idea of what personal data do they collect. And as Jean pointed out, that definition is now very broad for the type of data that we're talking about. So first of all, have they identified what personal data they're collecting? And then they need to know, who do they collect it from? So in what context do they collect it? Is it customers of theirs? Are they acting as a service provider for another company? Is it business to business? Because we didn't talk about this, but most states' privacy laws don't apply to business personal information. It's really focused on consumers. The big exception is California. Their privacy statute, even though it's called a consumer privacy statute, does apply to business personal data and employee data. But you have to know what data you're collecting and who you're collecting it from. And then you need to know some things about, where are you storing and processing that data? So in what systems, which part of your technology are you doing that in? What are you using it for, and who are you sharing it with, right? Because those are keys to the privacy regulations and compliance. You have to tell people what data you collected about them. You have to tell them what purpose you're using it for. You have to tell them who you're sharing it with, at least, the categories or types of other companies that you're sharing it with and what they're using it for. And then you have to be able to respond to the data subject rights request. So that means the request to delete, the request to know what data you have about them that Jean mentioned earlier. So it really starts with some level of data management and data governance, and just knowing what data you have, knowing where it is, knowing how you're using it and who you're sharing it with. That's the foundation. And you can do that in various levels of detail. Obviously, some bigger, more mature companies may have a lot of tools and technology to do that. But for small companies, it may just start on a spreadsheet, really going through their different lines of business and understanding what data they're collecting.
So, Joel, what are the biggest challenges you're seeing for companies right now with compliance?
Yeah, I think the biggest challenge does start with that foundational layer, because we think of companies in today's technology world as knowing all about their data, but I think that's really the exception, not the norm. And so it does start with that. I mean, the first challenge is just having that base level of knowledge of the data you have and how you're using it. But overall, coming from the regulations, I think the two biggest operational challenges for companies are around digital tracking and probably those data subject rights that Jean mentioned. So digital tracking involves using common technologies online or in your app that automatically are collecting information about users of the site or app. And that's usually done through some kind of tracking technology like a cookie, a pixel. If it's in an application, it's usually a software development kit or SDK, as the IT guys call them. And the challenge with these is that they're often invisible to the user, right? The user's just visiting the website or using the app, and they may not know that you're automatically collecting data about them and sharing it with third parties for analytics or for advertising. But what you need to know is, as the site owner or the application owner, you're still responsible for that data collection and use. And if you or those third parties that are collecting that data use the data in a certain way for advertising or to create a profile people that is derived from several different sources or different companies' websites, then you have to allow those users to opt out of the data. And, that's a challenge, right? Because some companies don't even know that they're collecting that data because the marketing team or the IT team just put these trackers on their site to get, and for good reason, to get analytics about how people use their site or to advertise to potential clients and grow the business. But you first have to get your arms around that you're collecting that data. And then you have to tell consumers you're collecting it and give an opt-out. So in today's market, the way companies usually do that is to implement some sort of consent management platform on their site or in their app. And a consent management platform is really a fancy name for what we usually experience when we're surfing the internet as cookie banners, right? Those pop-ups that tell you, hey, this site uses cookies. Do you want to allow all cookies or some cookies? And usually that's a way to tell people we're using these cookies. You didn't know it. You wouldn't know it if we didn't tell you because they're behind the scenes. They're invisible to you. But you have the right to opt out of some of the cookies that share data with third parties, especially for targeted advertising. So just implementing that operational piece on the web is a challenge because, like I said, a lot of companies don't even know that they have that data. And similarly, the other thing Gene talked about was the rights that these state privacy statutes give consumers to ask you, hey, what data did you collect about me? And request that you delete the data or correct the data. So if you get one of those requests, right, and you haven't done that data management where you know what your sources of data collection are and where you're storing and processing that data, it can be a real challenge to find out whether you have data about the person that wants to delete it or wants to know what data you have about them, and then implement that action, meaning tell them what data you have about them or delete their data. So those two things, I think, because they have operational lifts for companies that are built on top of some level of data management or data governance, are where we see the biggest challenges, because it's no longer about just putting an extra line or sentence in your privacy policy or just having a privacy policy that has a lot of legalese. It's about actually implementing operations with your data that respond to the consumer rights.
All good points. Many of our clients have said it's in my privacy policy. So those are all good reasons to bring that up, put it right in front of the consumer who now has an expectation of being able to opt out should they choose.
Absolutely.
So I want to pivot in this little last segment. Oftentimes, despite our best efforts, compliance may fall short, whether intentionally or unintentionally. And as we alluded to earlier, that can result in class actions brought by plaintiffs' attorneys or regulatory actions by federal or state regulators. So I want to focus a little bit on enforcement and maybe some red flags that companies should be aware of to potentially and hopefully avoid getting caught up in litigation, again, whether private or state action. Generally speaking, I'm going to focus a little bit on the CDPAs that have been passed, because that's kind of the elephant in the room and has provided more tools for regulators and in some cases, consumers on the private right of action side. What's important to note is across these 16 CDPAs, all of them grant enforcement authority to mostly a state attorney general office to enforce, and there are certain statutory penalties. Some of them, in limited circumstances, also grant a private right of action. California, for example, has a limited private right of action in their CCPA, where that could potentially expose a company to, again, a class action or a private suit. And so that can be the basis for private litigation in addition to general tort theories. But we have also seen state attorneys general start to become active in enforcing these laws. I'm going to use the first two CDPAs that were passed, as an example, California and Virginia, they were 1 and 2. The statutory penalties for violating both of those statutes is $7,500 per violation. That's the statutory remedy prescribed in the statute. There's also injunctive relief that is allowed, which means these state entities can compel companies to make certain changes to the way they operate, the way they process data. And we have seen several examples of that recently in California. There have been notable actions taken recently against DoorDash and Sephora, various other breach settlements that have come out. I can tell you, when I was in the Virginia Attorney General's office and I was handling privacy matters, we would, of course, receive breach notices per our data breach notification law. I can tell you that the vast majority of breach incidents occur within small to mid-sized companies. They're not the large companies that you often hear about in the news. And oftentimes the breaches might involve one person's information, a handful of persons' information, not the million. And with some of these privacy statutes on the state side, data breach notification and the thresholds with CDPA, sometimes it doesn't matter how many people are affected for a regulator to find a statute to enforce, whether it's consumer protection or, again, data breach notification. So I say all this to remind companies that, again, doesn't matter the size of your company. It doesn't necessarily matter even the size of the breach for one of these state laws to be triggered or even one of the federal regulations I mentioned. Now, to kind of wrap up, states get thousands of notices of breaches that they investigate. What are red flags to them? They can't investigate every breach. Most states can. And the same goes with the federal regulators. There are certain aggravating factors regarding a data incident or a breach that will kind of raise a red flag for a regulator. That'll be one, the size of the breach. Again, it doesn't necessarily matter the size, but that's one factor. The larger the breach might garner more attention. But beyond size, the type of data involved here, I mentioned sensitive data. If we're talking about children's data, health data, medical data, that's likely to garner the attention of regulators. The population demographic, a more vulnerable population that is affected, say the elderly or children, would garner more attention. And even the publicity the breach gets. If there's a lot of media publicity in some extraordinary circumstance surrounding a breach, that might garner the attention of a regulator. So again, paying attention to the data points collected and the data points involved and appropriately consulting counsel beforehand on the compliance side, but also quickly, should you suffer an incident, quickly alerting your legal counsel to help mitigate the damages. Considering all these factors we've talked about today, will go a long way towards resolving it. So with that being said, I want to turn it back over to Aurelia, Beth, and Joel for conclusion and any takeaways you all might have on what we've talked about today.
I think it's a great conversation, quite honestly. I think it's also one that will need to continue. Again, I feel like we're just starting, even though we've been working on this for a couple of years. I feel strongly that this is just going to be a conversation that's going to be part of our everyday language moving forward. So I appreciate the time that we've spent together, but I do think we'll be spending more time talking about this and educating our clients about this. So I just appreciate what you've done for us so far.
Well, thanks, Aurelia, and we certainly look forward to spending more time with you as well, but hopefully in a compliant, fun way.
Yes, exactly.
I think for companies, for small and mid-sized companies, I think the takeaways are, first, just being aware that these issues are out there. And then secondly, when they're confronting the issues, really it comes down to asking some of those questions to know what might apply to them, and asking some of those internal questions to know what data they have and how they're using it, because that will be key to figuring out where their risks are and how best to address them in a business forward manner. So hopefully this helps at least raise those issues and give some guideposts on what to look for. Aurelia and Beth, we enjoyed having you and working with you as always. Thanks for participating in this podcast, and we look forward to tackling these issues with you.
Gene and Joel, thank you for your engaging conversation with Aurelia and Beth. I've no doubt that your insightful dialogue and valuable perspectives resonated with our listeners as much as they did with me. And a big thank you to our audience for tuning in. Remember to subscribe to this podcast through Apple Podcasts, Google Play, Stitcher, or whatever platform you choose to use. We look forward to having you join us next time.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.